Good afternoon, everyone. Welcome to the Appellate Division First Department. We have oral arguments for today, April 2. Before I call the count, I just want to acknowledge two students from Cardozo. Where are they? There they are. They are actually students of Justice Michael. We have today Gabrielle Benes and Chloe McLaughlin. They are 1Ls at Cardozo, yes? So please be on your best behavior so that they want to continue and become 2Ls. So when I call the calendar, please ask for the time that you actually need in order to get out the salient points of your arguments. Please keep in mind that we have read your briefs. We are fully familiar with the arguments. Also, please keep in mind that the red light is for you, not for us, so that if we do have additional questions, we will certainly put them to you. People v. Angel Rivas. 312. Camacho v. Nycha. Mr. Camacho is here, yes. Mr. Camacho, how much time are you requesting? 3 minutes, that's good. Nycha? You don't have a course up here. 3 and 3. Aileen G v. Catherine V. That matter is submitted. Light and Wonder v. Mohawk Gaming. Good afternoon. I know, 2 o'clock, it's afternoon, trust me. Yes, sir, I'm sorry. 5, 2, and 5. People v. Carlos Gonzalez. That matter is submitted. People v. Urena. That matter is submitted. Ramirez v. 2500 Web LLC. 525. Gottlieb v. Mountain Valley. 525. People v. Amir Casaberry. That matter is submitted. Bank of New York Mellon v. Miller. That matter is submitted. Lima v. Skyline Restoration. 525. People v. Wisdom. 626. Wells Fargo v. Moreno. Matter submitted. Murray v. Planned Parenthood. Ms. Murray? 525. Harvey v. New York Foundling Hospital. That matter is submitted. People v. Sean Terry. That matter is submitted. Maddox v. 106-108 Convent. That matter is submitted. First case for argument is People v. Angel Rivas.
Good afternoon, Your Honors. Harold
Hi.
Ferguson for Appellant Angel Rivas. What the prosecutor is asking this court to do is overturn a precedent that this court has reaffirmed more than 30 times from Arias, including today in Fabian Brown in a case which Justice Mendez was on. The decision is based on, the precedent was based on a series of Court of Appeals cases, Hakes, Fuller, Letterloff, and there's no reason for this court to overturn
So we have almost every condition of probation possible that was checked off, right?
Yes.
Okay. And so there are a couple, and your client was convicted or pled guilty to CPW 2?
Attempted CPW.
Attempted CPW 2. And so you are, what conditions are in particular?
Well, there are several that the people have conceded to. The ones that are in dispute are the ones related to drug and alcohol testing, substance abuse treatment, and mental health treatment.
That's 22. 22 is the alcohol and substance abuse treatment.
I think it's 15 and 23.
15 and 22.
And, Your Honor, in People versus Balo, a decision that both Your Honor and Justice Michael were on, controls this. It indicates that when there is no indication that the person it has any type of drug or alcohol problem, that there is no need for testing or for treatment. And in point of fact, the Department of Probation, the pre-sentence report indicated that there was no need for either mental health treatment or drug and alcohol treatment. And therefore, based on Bay law, a case that came down just in January of this court, that controls the situation. And therefore, we ask that those conditions of probation, as well as the ones that the DA has conceded to, be stricken from Mr. Rivas's situation.
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. Mary McGarvey Depew for the People.
So you actually opposing that application?
On 15, 22, and 23,
Oh, he's in possession of a weapon, yes?
he was in possession of a weapon. I would note that probation condition 23 doesn't just cover alcohol and substance abuse programming. It also includes
Domestic
alternative
violence,
to
or
violence.
is that the one that domestic violence?
No, alternative to violence.
Yeah,
And the
domestic violence or alternative to violence program as directed by the Department of Probation.
And the Department of Probation did note that the fact that he carried a loaded weapon on a Bronx street is indicative that he has tendencies that, unless he's properly supervised, could continue.
For domestic violence?
To violence. I mean, he was carrying a loaded.
Domestic violence?
No, alternative to violence is the next one after domestic violence.
But domestic violence is in there as well, right? Participate in an alcohol substance abuse intervention, domestic violence, or alternative to violence program. That's condition 23.
True, if directed by the probation department, and B, in this.
So what is there about the defendant, about his history or about this particular crime, which would in any way indicate that he would be in need of any services as to domestic violence or alternative to violence program or alcohol substance abuse intervention?
The alternative to violence would be the fact that he admitted to carrying a loaded gun in his shoe. And in terms of of substance abuse, this defendant admitted to smoking 5 marijuana blunts per day from the age of 12. He was 21 at the time of this plea and sentencing. Also, he lied to probation on a number of occasions. So given all of those factors, the people's position is that 15, 22, and 23 are reasonably related to his probation, and also that this case is not controlled by bail. As we know, the court looks to each individual defendant, but it's closer to Roosevelt, where this court upheld the imposition of conditions 15 and 23, where a defendant was found in possession of a loaded gun, admitted prior use of alcohol and marijuana, and he associated with the wrong crowd, which is what the defendant did here.
Thank you.
Thank you, Your Honors.
And besides in bail, it also indicated, this court, that there was nothing that indicated that drugs or alcohol were in any way related to the offense here. And this was my client's one and only brush with the law, and that we ask that all of the conditions of probation be stricken.
Thank you.
Thank you, Your Honor.
Camacho v. Nitro, New York City Housing Authority. So, Mr. Camacho, you're going to go first. If you could just stand by pull the mic down. So you have 3 minutes to, you can be seated. Mr. Camacho, you have 3 minutes to talk to us about this particular case.
All right. How you doing? I don't really know what to say, but I'm just going on because
If you could pull the mic a little bit closer. Thank you.
they took me to court, I think it was last year. They told me to go to court because I wasn't on the lease on housing for my aunt. I gave them all the proof that I was living there. So they told me to go to court. I took it to court. I went to Article 78. Once I went to Article 78, the judge looked at everything, all my information that I gave to them. I've been paying rent with my name on it. My aunt is deceased. She's been deceased since 2020. So the judge decided to go on my favor and gives me the apartment and told them to put me on the lease. So, been waiting over a year now to put my name on the lease. They called me and told me, oh, we're gonna appeal it now, a year later. And now I'm here now, trying to fight for this apartment again. But I've been there since 2018, with my aunt taking care of her since he was sick. And she tried to put me on the lease and everything, but they denied it. And told me that I wasn't family. But I proved it, that I was family. I gave them everything. The judge saw everything. The judge decided to go in my favor. Gave me it and told them they have a certain time to give me my lease. But they didn't give it to me. A year later, they want to bring me to Supreme Court now. Right now, if I lose or not, I have no place to live.
Thank you. So you do have, you will have additional time. I'm sorry, actually, you should have gone first. I forgot that you were the appellant, Nature, but go ahead. I'll give you time on rebuttal as well.
Good afternoon, Your Honors. Alexander Lloyd for Appellant Nature.
Can you speak into the microphone? Pull it up.
So the issue here is the familial category policy revision that occurred in January 2024. This revision removed the familial category requirement that limited the categories of persons that could join the household. This revision was made after permission had been denied in 2019 on that basis, after the tenant of record passed away in 2020, after our hearing officer held a full hearing on the record and issued the decision in October 23, and the revision occurred after.
NYCHA's been taking rent all of this time, right?
Yes, that's a requirement under the RFM grievance policy.
No, I think the point was that Mr. Camacho has been paying rent during this period, during the entire period of time.
Right, the requirement to pay use and occupancy is part of the RFM grievance. So if he hadn't been paying use and occupancy, he wouldn't even be entitled to
So
an RFM grievance.
the point is, he's paying rent during this period of time. He's in the apartment, but yet now he was denied. NYCHA denied him access to the apartment after his aunt died, right?
We denied him succession rights.
Succession rights.
We first denied him permission to join the household based on the familial category requirement.
Yes.
In terms of timing, does it matter that the tenant's son requested that he be added to the household over a year before she passed away?
No, because the tenant's son wasn't a member of the household. Only the tenant of record has standing to request permission for new household members, which,
The son couldn't ask on his mother's behalf?
sorry, what
The
was,
son couldn't ask on his mother's behalf?
no, she's the tenant of record. It's her job to,
How do you determine who the tenant of record is?
who signed the lease.
The lease?
Yes.
And she's the only person on the lease?
She's the only person on the lease. It's her job to maintain the household composition, meaning to report to NYCHA who,
The son was asking because the mom was ill, right? And needed someone to take care of her. That's why that's why the son submitted the letter, correct?
the son submitted the letter asking for a petitioner to join the household to take care of her, yeah.
Because the mother, the tenant of record, was ill and ostensibly could not do this on her own behalf.
But she did do it on her own behalf in March. So she was able to do it on her own behalf.
So she did it she requested it in March and then it was denied?
In April, yes. Based
What
on
happens if she was unable to? Because at the time that the son made the request, you had no idea whether she was able of making the request herself.
if the son told us that she was genuinely incapable of doing that, we can,
And that couldn't be inferred by the fact that she was ill, and that's why he was looking for his I'm not sure what the relation is, the uncle, whatever it is, to stay to take care of the mother.
the petitioner is the nephew.
Right? Did you miss the point of my question?
Sorry, could you state that again?
That at the time that the son made the request,
Right.
he stated that the mother was ill, and that's why he wanted the nephew to join the household, right? So he could take care of the mother. Couldn't you infer from that that she could not make the request herself?
But then she made the request.
You didn't know that at the time.
Right.
You didn't know that with the first request, because the second request had not yet happened, correct?
Correct.
And I'm asking you, at the time that you got the first request from the son, wouldn't it have been a reasonable inference that she could not make the request herself because the son was making it on the basis that she was ill?
So I can't speak to property management's mindset when they received that letter. I don't know exactly what they communicated back to the son. But the tenant of record is responsible for filing all of the documents associated with upkeep. That means annual recertifications. That means any amendment to the income or the household composition. If she was truly incapable of requesting that, we regularly accept a power of attorney or some other document that says I can make these decisions on behalf of, this maybe ill or incapacitated person. In that case, we would have provided that. I don't know exactly what the conversation was between property management and the son when they received that.
Thank you.
Presumably.
I will give you time on rebuttal if you need it. Anything further, Mr. Camacho? No. You wanted to add anything? No? Anything further? No, Your Honor. Thank you. Thank you both. Light and Wonder v. Mohawk Gaming Enterprises. Yes.
Good afternoon, Your Honors. Kevin Orsini, Crevasse, Swain & Moore for Light and Wonder. We're here on a decision by an arbitrator to certify a class of casinos that my client does business with. The most fundamental tenet of arbitration law is that it's a matter of contract, and therefore it's a matter of consent. And so as the Supreme Court, this court, and the Court of Appeals have explained time and again, the very first inquiry in any arbitration dispute is what did the parties agree to and what was their intent. We have the right to structure our arbitration agreements how we want and to have that enforced. This is the very rare case in which the arbitrator's decision is not entitled to any deference.
And why is that?
The reason for that, Your Honor, is because as this court has said and various others have said, an arbitrator that draws a decision from the essence of agreement is entitled to discretion. One that does not, one that refuses to look at the agreement, or that issues a decision that contradicts expressed terms of the agreement is entitled to no deference. That's precisely what happened here in two ways. First of all, the named class representative, Mohawk, has an arbitration clause that says one arbitrator, New York venue, no requirement for negotiation or mediation before an arbitration. As we pointed out to the arbitrator, many of the absent class members have contracts that say things like 3 arbitrators, venue in New Mexico, various other states, negotiation and mediation. None of these contracts actually address class cert directly. But the point is, I don't have any doubt that if I were before this court in a single bilateral arbitration with one of the absent class members, and the contract said 3 arbitrators, and the arbitrator said, no, sorry, I think 1 is more efficient, you would vacate that decision. That's exactly what happened here, and the fact that it's a class action doesn't change that result. The only argument that the arbitrator put forward was, well, if the casino wants 3 arbitrators, they can opt out. But we have contract rights too. And the arbitrator ignored those and is forcing us to go through an arbitration that is directly contrary to a number of these absent class member clauses with respect to the number of arbitrators and various other procedural issues. That's issue number 1. Issue number 2 is the arbitrator decided that Mohawk's clause permits class arbitration even though it doesn't talk about it. We disagree with that. We brought that up. This court affirmed that decision. We'll live with that. We obviously have to. That was a decision that was entitled to discretion because while I disagree with what the arbitrator did, the arbitrator at least was interpreting the arbitration clause. There are roughly 2 to 3 dozen class members who have the very same clause. And we concede, given the prior ruling of this court, Those go to a class arbitration. The problem is the other roughly 100 clauses that are fundamentally different, that do not speak to class arbitration. One example, the best example, candidly, is at 600 in the Record on Appeal. This is the Harrah's Action arbitration clause. That arbitration clause simply says, any dispute among the parties hereto, my client and Action, regarding the interpretation, performance, breach, or enforcement of this agreement shall be submitted to and resolved by arbitration. That does not permit class arbitration. Multiple decisions.
So does AAA,
Yes, Your Honor.
AAA class rules apply? Is that correct?
So AAA class rules apply, but AAA class rules cannot override contract terms. And what the AAA contract rules say is that the arbitrator has to decide whether the other clauses are substantially similar.
Right.
We
But
can-
it does contemplate that the arbitrator is going to make a determination in evaluating factors, right, in terms
does.
of the class status, yes?
It does, Your Honor.
So how in this instance can we state that the arbitrator's decision was inconsistent with class certification under AAA?
So on the first point I made, which was the contracts that have 3 arbitrators, not 1, that to me is obvious, right? He's overriding express, unambiguous terms. There is no case that has ever been cited that says he can do that.
Why is it required that the arbitrator look at those other contracts in order to certify the class?
Because, Your Honor, as the Supreme Court has said time and again, because it's a matter of consent, where you start is...
When you say the Supreme Court has said time and time again, are you talking about the Lamps case?
I'm talking about Lamps Plus, I'm talking about the Coinbase case, I'm talking about Stolt-Nielsen, I'm talking about AT&T.
Did those cases deal with specifically certifying a class?
So Stolt-Nielsen and Lamps Plus dealt with whether or not there had been agreement to class arbitration. And in those cases...
That's different, you would say, from certifying a class, right?
I would not say it's different on the issue we're here about, which is whether or not we consented to arbitrate on a class basis with every member of this putative class. And what the court said there was, in Lamps Plus, where they were dealing with form agreements that applied to all class members, we have to look to see if the party consented to class arbitration. Here, we didn't. And back to your question, Your Honor, on whether the AAA rules foresee or contemplate him making a decision, absolutely. And if he had gone through the contracts and he had gone through the clauses and said, you know what, Mr. Rossini, I disagree with you. I think the Harrah's clause does reflect intent on your part and their part to arbitrate on class basis. I have a much different chance in front of this court. I have a much different argument. That would be entitled to deference. He didn't do that here. He refused to do that here. What he said was...
But he did wrestle with the issue, correct?
He wrestled with the legal question of whether or not, in his view, he was required to decide whether we had agreed to class arbitration with each absent class member. His conclusion was he's not. He said, that's not what Lamps Plus is about. That's not what Stolt-Nielsen is about. I think that was manifest disregard of law. That's not what those cases say. But it also is a manifest disregard of the contracts. And that's my point, Your Honor, that he did wrestle with whether or not he had to look at the contracts. He said he didn't. I am aware of no case ever that says an arbitrator who derives his authority only from the contract can make a decision not to look at the contract, including because he said, Your Honor.
You didn't look at some of the sample clauses put forth in those contracts?
We put them forth. He did not analyze them. If you look at his decision,
I thought he stated that he was analyzing them.
he analyzed the issue, the first issue I talked about, which is 3 arbitrators, different venue, and he said that's not sufficient to render them not substantially similar. If you look at his decision on the class certification, on the question of whether or not we agreed to class cert with each of these, to class proceedings, which each of these class members, he said, I don't have to look at it. It would be unmanageable to look at it. And he doesn't engage anywhere with the analysis he did in the clause construction award as to whether or not the specific language of each clause reflects an agreement to arbitrate.
You have time on rebuttal.
Thank you, Your Honor.
Good afternoon. Michael Eisencraft, Cohen Milstein Sellers and Toll for Mohawk and the class.
So do you agree with your friend that the arbitrator did not, in fact, look at everything and analyze everything in coming to his determination?
The arbitrator did exactly what he was supposed to do under the AAA rules and as he was entitled to do under the contract between Mohawk and Light and Wonder.
Was the arbitrator required to look at the other contract clauses with the other other entities in the class certification action?
He was required to do so that he could determine if they were substantially similar or not under the AAA rules. That's a requirement for certifying a class.
And did he do so?
He did. And what they're complaining about now is he didn't look at every single one of them because they chose not to submit every single one of them. Instead, they
There were
submitted.
samples, right? That were submitted.
Exactly.
And he did state that he was looking at those samples, right?
He did. And we submitted our description of them. They submitted their description of them. And they submitted their samples that they thought were most advantageous, that showed the most dissimilarities. And he looked at those samples and he said, no, those are still substantially similar. And that's.
Was the arbitrator using his own policy considerations, or was he doing this based on the governing law?
The governing law entirely. There was no policy consideration at all, except to the fact that he looked at their interpretation of the governing law and said, not only is this contradicted by the law itself, other precedent, but it doesn't make any sense in its application, and that is an acceptable canon of construction. It's not imposing his own policy considerations. He's interpreting the law.
Your adversary has argued that consent to arbitration is really what is at the heart of this issue here. Can we find that the other members of the class consented to arbitration here?
Absolutely. The class is restricted to those entities who consented
To class arbitration versus
they consented to AAA arbitration. Whether whether class arbitration is permitted or not is a gating issue, and that was determined by the arbitrator with respect to the Mohawk contract. That permitted class arbitration. That was affirmed by the commercial division in this court. Once class arbitration is permitted, the only issue is how big, whether the class should be certified, and how big the class is going to be. And that is determined by the AAA rules, specifically, and those rules basically follow the federal rules with the additional requirement that the arbitration clause be substantially similar. So that's what he was bound by. That's what Mohawk and Light and Wonder agreed to, and that's what. So because the question is whether those absent class members should have the option of joining a class. They can opt out. In fact, we sent out class notice, and one of them opted out, and that's their prerogative. Under Phillips v. Schutz, joining being an absent class member does not require the same affirmative duties and requirements as being a litigant in a lawsuit. You're given an option to join a class. They were given this option. Most of them, all but one of them, took the option. But that's what the AAA rules about certification require. It's not like you have to look at each contract and analyze what they are, it's not what they're agreeing to.
Your adversary also indicated that the decision here manifestly disregarded the rules promulgated in the Lamps case. How do you respond to that?
It absolutely did not. So to manifestly disregard the law, it's a two-pronged process. First, the arbitrator has to ignore or, basically defy a ruling. That did not happen here. The arbitrator heard their arguments, he wrestled with them, and he gave a ruling that they did not like. That is not ignoring them. Second, it only applies to basically on-point binding precedent. There is no on-point binding precedent here. Lamps Plus, as this court just recognized an argument, did not discuss what the requirements were for analyzing absent class member contracts. Their argument is a novel one. It is a clever one. It is an issue of first impression. As Justice Chan found, there is no case law adopting the position they're looking for. And in fact, arbitrators have gone in different directions and never applied this supposedly mandatory tests. So he did not manifestly disregard the law. He wrestled with the issues, and there's no binding law to guide him on this issue.
Because Lamps Plus and also Stokes are kind of unclear, right?
So they do not deal with this issue at all.
Disregard something that's really not clear.
Correct. And I think the last argument they made was that he exceeded the powers granted to him, but class arbitration was agreed to by both parties here. That was affirmed by this court. And then we made a motion for class certification under the AAA rules, and he ruled on that motion. He has not exceeded the powers that were given to him under the contract. I see my time has expired.
Thank you.
So I fundamentally disagree that the arbitrator analyzed the contracts as it relates to whether or not any absent class member agreed to class arbitration. If the court reviews his decision, which is at record page 40, and in particular pages 49 and 50, those are the pages where he grapples with our argument that every class member must have agreed, and we must have agreed with them, to class arbitration.
So you're saying basically that he should have reviewed every single one of the contracts?
Yes, Your Honor, he absolutely
Not
should.
a sample, but every single one of the contracts.
Correct, Your Honor.
And how many contracts do we have?
There were roughly 120. And yes, that is a lot of contracts to look at. The Supreme Court said in the Dean Witter case that because arbitration's about contract and consent, concerns about efficiency, concerns about, the burden on an arbitrator cannot override the obligation to actually look at the contract, interpret it, and apply it. And if you look at pages 49 and 50, he does not do that. He says he doesn't have to do that. His position is what Mr. Eisencraft just said. And he said it well, but not directly, which is that their position and his is, once it was determined that one casino had agreed to class arbitration, now we're in the class world and we only have to worry about the class certification principles that the AAA sets forth. And so what's the extension of that? Even if we did not consent to resolve Harrah's claim, which doesn't even cover antitrust claims if you look at it, which this case is, even if we hadn't consented to do their case on a class basis, it doesn't matter because someone else did.
So he's reviewing the contracts to determine whether or not they're similar, right? In terms of the clauses are similar.
So yes, Your Honor, but not on this issue, right? If you look at page 11 of his decision, which is page 51 in the record, where he gets into particular differences in the clauses on similarity, that's where he's addressing our argument about 3 arbitrators versus 1 and venue.
My point is, or my question is, so you want him to review, you said there were 100 some odd contracts,
Yes, Your
yes?
Honor.
And so he reviews those 100 some contracts, and there's similarities in terms of the clauses, so then what?
So he has to decide whether each member of the putative class, or they have the burden to demonstrate whether each member of the putative class is someone with whom the opt-out doesn't solve anything. We have contract rights, whether we consented to class arbitration. And he doesn't have to review about 30 of them because we agree they're the same as the one for Mohawk. But the others, and we gave him exemplars that he does not engage with, the others do not show consent to class arbitration. We're entitled to structure the program as we want. He even says, well, no one has told me that there's anything in here that precludes class arbitration.
And what about the fact that they could simply opt out?
Again, Your Honor, that doesn't solve the problem, because if that solved the problem, then you could simply say, well, 3 arbitrators versus 1, if they want 3 arbitrators as the casino plaintiff, they can opt out. What about our rights? It's a bilateral agreement. Consent has to be from both sides. So we should have the right to opt out as well if we agreed to bilateral arbitration, which is what we did for many of these casinos.
Thank you. Thank you both.
Thank you, Your Honor.
Ramirez v. 2500 Web LLC. Yes.
May it please the court, Jonathan D. Moran, Gorab and Associates for the plaintiff appellant in this matter. Your Honors, I respectfully submit that the trial court erred in denying plaintiff's motion for summary judgment on his Labor Law 240 sub 1 cause of action. I respectfully submit that the record at bar shows that the portion of the sidewalk bridge that fell and struck the plaintiff in his head should have been secured for the purposes of the undertaking, and that the failure to...
What was the purpose of the undertaking?
To dismantle the sidewalk shed, Your Honor.
Dismantle, to bring down the shed.
Correct, Your Honor.
And so as they're doing that, one of the poles, or is it the one that someone is holding, or one that is horizontal, falls and strikes the plaintiff?
Sure. So there are two vertical posts. One is being held by the plaintiff in this matter. The other is being held by one of his coworkers. Those two posts are connected by a horizontal pipe. Ooh, I'm sorry. Is being connected by a horizontal pipe. Wrecking the joint. Is being connected by a horizontal pipe. One end connected to the post held by the plaintiff. One end held by the coworker.
Mike just doesn't like you.
It doesn't like me. The portion of the horizontal pipe that was connected to the vertical post being held by the plaintiff was loosened but not removed and left in a loosened state while they went to go remove the other end of that pipe that was connected to that other vertical post. When the coworker holding the other vertical post,
There's some confusion on your client's part as to whether the pipe that fell was a vertical pipe or a horizontal pipe.
Right, I was going to say that your recitation is great, but it really is
Other
not what
than-
your client's recitation was in terms, and I understand he stated, you know, he always gets confused between vertical and horizontal. But your recitation was really good.
Thank you.
But it varies somewhat from your client's recitation of what occurred.
I acknowledge that the testimony does take sitting with to a degree. So if really the critical pages I would submit to your honors that require attention is pages 182 through 185. At page 182, he testifies that the horizontal pipe, the end of it that was connected to his post, was loosened. At page 183, he says the loosened pipe is what hit him.
Counsel, does it make a difference whether it's a horizontal pipe or a vertical pipe?
Just for purposes of understanding what portion of it was that hit him, but I would submit it doesn't.
Other than that,
No,
he got hit by a pipe, right?
He got hit by a falling pipe, subjected to the forces
And let me
of
just say
gravity.
that workers' comp, I think he, in the workers' comp incident report, he says it's a vertical support pipe. But the bottom line is, they are taking down the scaffolding. They are, the term that was used was deconstructing, right?
Deconstructing, disassembling.
Deconstructing. So you mentioned something was loosened. If you're taking down the scaffolding, if you're deconstructing, is that not the object, is to loosen so that you can remove it?
Well, if it's going to be left in a loosened manner, Your Honor, I would submit that it has to be left in a loosened but secured manner so that it doesn't fall uncontrollably onto the person that's standing underneath it.
How would that be accomplished?
Well,
What kind of safety device or?
you could put somebody on a ladder to hold it until it's ready to be lowered to the ground. You could secure it with a sling, a chain, a hoist.
Was that something that was raised below? I mean, this is the safety device that they should have used and they failed to use it?
That was not borne out in the record.
There was nothing in the record in terms of what safety device that could possibly be used in order to prevent this type of accident, this alleged accident.
True, but I would bring to the court's attention the case of, Thompson v. St. Charles Condominiums, which says that 240 is violated even when the safety device collapses with the worker either on or under the scaffold. I would also point out that in the Leveron matter, it was a
That case that you just pointed out, that had to do with a fallen object?
Yes, that had to do with a scaffold being used by brick masons. Cinder blocks had been placed on the scaffold, several of
The
them.
scaffold was being taken down at the
It
time?
was not that in that case. It was not being dismantled, but it did collapse on top of the plaintiff who was underneath the scaffold at the time.
Right, but it wasn't, the scaffold in itself was not being taken down, so the facts are not the same here.
In that particular regard, the facts are not the same.
Okay.
But I would also point out the Leveron case in which the sidewalk shed was being dismantled, and several of the portions of the deck in that case from the shed collapsed on top of the plaintiff. In that case, they were dismantling the sidewalk shed. It did collapse on the plaintiff, and I would say that informs this case, which is that the sidewalk shed should not have been left in a condition, even while it's being disassembled, in a state where it collapses on top of the plaintiff.
Well, I think that's the issues. Well, yes, you do have time.
Good luck.
May it please the court, Nicholas Calabria with the law firm of Ami Demirs.
Yeah.
Excuse me?
It's your turn to grapple with the mic.
Doesn't collapse on him.
For the respondent, 2500 Web LLC, I believe the court correctly denied the plaintiff's motion for labor law section 240. The pipe scaffolding that they were dismantling the very pipe scaffold that they were dismantling is the object that struck the plaintiff.
Right, well, I mean, I know it was stated that it really doesn't matter because he was struck by a pipe, but to some extent, the inconsistencies as to whether it was vertical, whether it was horizontal, et cetera, do to some extent matter in terms of whether that portion that struck him was being dismantled at the time.
Well,
Right.
again, it was confusing, and we've tried to point out, I guess, the varying confusing stories that were told. But regardless, the three pieces were coming down, and that's what they were taking down at the time that the plaintiff was injured.
So
It was the
couldn't
intended
it
target
have
of the
been
demolition.
prevented, this piece falling on the plaintiff? Couldn't it have been prevented by using some type of securing device?
Well, I guess the logic of it is if you're taking it down at the same time you're securing it, how can you take it down if you're
That's
securing it?
Holding
prevent
it.
it from falling. I mean,
Right.
it's not like you loosen it and throw it down and it hits whoever it hits, right?
Well, so the problem in this case was probably where the plaintiff was standing. I mean, it had nothing to do, they were purposely dropping those pieces of scaffolding.
I thought that one of his coworkers bent over and sort of knocked it, and that's what caused this.
Yeah, but they were dismantling it when it came down. I mean, what they
You
were,
use the word drop.
yes.
It's not like they unhook it and drop this pipe down, right? They're taking down the scaffold, but to use the word drop sort of implies that they could care less what happens once they take it off.
Well, I don't know what they were doing because the way this story is told, could they have been taking it down and dropping it? Possibly. And again, it's just a general hazard of the workplace. It's
But
not,
if your friend's recitation is correct in terms of the coworker was loosened the pipe, right? You can loosen it, but still secure it so that it doesn't in fact fall, right?
well, again, if the intent was to bring that down, that was the whole purpose
Okay,
of
but
what was-
what my point is, you loosen it, but then you still hold on to it, you still secure it, so it does not in fact fall.
and
In
it
other words,
was-
it could be a controlled descent, right?
Right.
Of course it could be. And again, if we had just one story, it would be a little easier to discuss what exactly was going on. The problem is with all the different scenarios that came down, a question of fact is presented, and therefore the labor law 240 should not have been granted. Thank you.
Thank you.
Thank you, Your Honors. I'll try to be brief and not repeat anything. I just would like to point out that there is no testimony or evidence on this record that my client was standing in the wrong place or somewhere he was not supposed to be during the disassembly of this sidewalk shed. And I would also note that irrespective of whether my client had some difficulty discussing the differences between something vertical or horizontal, the facts remain and are undisputed that he was struck by a portion of the sidewalk shed, which I submit to Your Honors should have been secured for the purposes of the undertaking, notwithstanding the fact that the ultimate goal was to disassemble it.
Thank you.
Thank you, Your Honors.
Gottlieb v. Mountain Valley. Yes.
Good afternoon. Rachel Herzempa Winship on behalf of Mountain Valley Indemnity Company.
I think you have to keep your voice up, please. Thank you.
Page 1 of the policy states that it covers a two-family dwelling. Respondents do not dispute that the premises contained an apartment on the first floor with its own kitchen, bathroom, and bedrooms, and an apartment on the second floor with its own kitchen, bathroom, and bedrooms. Crucially, respondents concede that the basement contained its own kitchen, its own bathroom, and its own bedrooms that had individual locks on the doors. And respondents also concede,
Does that make it a three-family?
correct.
I'm asking.
Yes, it does.
That in and of itself make it a three-family?
Yes, considering all of the factors at play in this matter, because respondents also concede that unrelated persons stayed in the basement, they paid their expenses.
Was there access from the upper level to the basement?
There were individual locks on the bedroom doors.
No. To be able to get from the upper level of the home to the basement level, was there a door that was locked?
Respondents testified that they could freely go in between the interior. However, there was a separate entrance on the side door apart from the main entrance that had a key code that they had access to come and go as they pleased.
But that entrance led not only to the basement, it also led to the rest of the house.
Yes, it did. But taking all of the factors, including that these unrelated individuals whom respondents could not recall the names of and could not recall the duration of their stay, as well as paying expenses, having locked doors, with the kitchen and bathroom taken as a whole, makes this at minimum a single room occupancy, if not a third.
I was going to ask, what do you make of the fact that the layout or the contention that the layout of this structure hasn't changed since the policy was issued?
That's irrelevant for the analysis here, as we're stating that on the date of loss, this property did not come within coverage under the policy as written as a two-family property.
Is that because it was structurally a three-family or because it was used as a three-family?
There is no real distinction here, as
There is, because under our case law, it's actual use as opposed to structural.
yes, but respondents are twisting this actual use language. If you read those cases, they're arguing regarding the certificate of occupancy. They're still looking at the actual configuration, whether there is their own kitchen, bathroom, and living area. The use per the certificate of occupancy is what was legally permitted. That's not the case here. We're not looking at a certificate of occupancy issue.
On this being your motion for summary judgment, let's talk about the proof that you put in terms of the affidavits. Were those affidavits enough, given that the affiants didn't say how they made their determination that this was a three-family home?
The affidavits included statements regarding what they observed when they went to the property. They stated they saw the individual locks, they saw the bedrooms, they saw the kitchen, they saw the bathrooms, they saw this separate entrance, as well as the two other apartments upstairs. That is sufficient, taking into account as well plaintiff's own testimony.
Would it matter that there were only two gas meters and two electric panels in the house?
Again, these are all factors to understand the totality of the situation, of the layout, of the configuration. That is one thing that can be considered, but that's not determinative. None of these individual factors are determinative of the entire situation, of the structural configuration of the property.
But taken as a whole, wouldn't that raise an issue as to whether or not it's being used as a two-family or a three-family dwelling?
I would respectfully disagree. The cases that this court have decided only look to the structural configuration, and they mentioned some factors that could be included, including a separate kitchen, separate bathroom, separate living area. They did not go into whether there were other.
Isn't key to that analysis whether the occupants have free access between the basement and the rest of the structure?
That is one factor they considered, but that is not determinative. It is one, and in particular, Almont is particularly instructive because this court affirmed the trial court's decision, which stated that Daria did not emphasize the existence of a separate entrance and actually looked at where.
That's a different question. That's about separate entrance. It's here. There's, as far as I understand it, there's no evidence that there were any locked doors that prohibited or prevented the occupants of the basement from traversing the rest of the structure.
Correct. However, Almont did look at where there was interior access from the upstairs to the lower level, and that was not a determinative factor where the person had access to side doors, they had access to their own bedroom, and they had access to their own kitchen and bathroom.
Thank you.
Good afternoon, Your Honors. Roman Rabinovich for the respondents. For the purposes of the appeal, we're not going to dispute that configuration under certain circumstances can impact the number of families analysis. We're not disputing that. What we're saying is in this particular case, they failed to meet the burden. And the reason they failed to meet the burden is because there's no separateness of the basement unit. They keep saying that there is, and they want it to be so, but there isn't. There's a side door that you could access the entire house. And when you get down to the basement, there's no door. So you could go into the common areas, you could go into the kitchen, you could go into the pantry. That's not separate. That's not a separate unit. Every
Well,
ca-
I mean, is it relevant at all that your client testified that they did rent out, or there were individuals living in the basement, and that those individuals, it was unclear whether they were paying rent or just contributing? Does that matter at all?
So the answer is in the other cases that cited, if you have a rent-paying tenant with a lease, that is a dispositive factor.
You
Here,
have
what
to have a
she's,
lease? I'm sorry.
No, that was my question.
Yeah, I don't remember those cases talking about a lease.
well, if you go
That's how we get to illegal tenancies, right?
right, so the cases that appellants rely upon, a couple of them have, during the course of the investigation, the insurance company found tenants that were residing there under valid leases at the time. I think Jefferson was one of them, and the others, the homeowners admitted to such an arrangement. Here, these weren't tenants; these were family, friends. She testified at the EUO very clearly.
Who your client didn't know who they were.
Well,
No idea as to their names, but did know that as I stated, that they contributed, and that they would stay there for a period of time and that they would contribute.
correct. So what
So
would
the
happen?
investigator found a separate side entrance to the basement, no access from the outside to the first floor, 4 bedrooms, full kitchen with food in the refrigerator, basement rooms used by family and friends. These individuals help with the bills. And also, the investigator submitted photographs showing a deadbolt lock on the door and furniture.
Right. So, and you bring up an excellent point, Your Honor. They're trying. They did try, and the investigator was very sensitive to the separateness issue. And so, in his affidavit, his sworn affidavit, he's actually contradicted by his own photographic evidence. He says the side entrance is separate and dedicated to the basement with no internal access. But in fact, page 150 of the record directly contradicts that, and that's part of the point. If you look at some of the other photographs, I mean, to the extent they're relevant, if you look at the fridge, you've got 6 packs of eggs and unopened condiments, which the insurance company investigator made hay of. But that's typical of an overflow refrigerator that would be used to supplement the space upstairs. The point being that people were staying there, and the other important point
Were
is,
or were not, I'm sorry.
I'm sorry?
People were or were not.
They were. They weren't residing there. But the other component is, as the insured and her insurance adjuster explained, this is an Orthodox Jewish household. So what happens is sometimes if you, and the fire happened over Sabbath. So what happens is if you invite people to come over and have dinner with you over Sabbath or a high holy day, which today is a first day Passover, where they're prohibited from driving,
But
taking
there was
mass
no
transit.
testimony of that or evidence of that. There was a holiday invited guest that was over.
She testified at the EUO that she was preparing for Shabbos when the fire occurred.
I know that,
and
but
that's
she
the
didn't
thing.
say anything regarding the guests, the individuals who were present at the time that the fire occurred, were there for the holiday.
I don't know. I don't know that she was asked specifically, but
Well, what she did say about the guests is that they had been there and they had been contributing.
no, she said respectfully, she says that over time, when guests would stay down there, if they stayed for a couple of weeks or a couple of days or whatever, and they came up and ate their food and used their utilities and used their water, they would contribute. That wasn't mandatory. There was no set agreement. It was just a custom in the community to do that. And they contributed to their bills, but not so much as rent, but meaning, sort of being thankful for the opportunity to be there.
Thank you.
Thank you.
I will just reiterate that it's the undisputed fact that the basement contains its own kitchen, its own bathroom, and its own locked bedrooms. It's a self-contained unit where unrelated individuals stayed, whom respondents could not even recall their names of or the duration of their stay, and they could come and go as they please with the side door access code.
Counsel, was this the same layout at the time of the underwriting?
That question's not before this court. The issue is on the date of loss. Was this a 2-family or was this a 3-family? And that question is irrelevant, respectfully, to the overall analysis of this question. And any other description of their story does not change the fact that basement was its own self-contained unit. And under this court's precedent, that's enough to say that this premises was not a two-family dwelling as required by the policy, and as such, respondents cannot recover under the policy.
Thank you.
Thank you.
Lima v. Skyline Restoration. Yes.
Good afternoon, Your Honors. Jeffrey Mazes on behalf of Defendant Appellant Skyline Restoration, Inc. Today, we're here because the lower court's limited reversal of its prior decision after plaintiff moved to be, after plaintiff moved for a re-argument without oral argument, the lower court changed its mind as to the limited scope of the common law negligence claim.
I don't know that I would say it changed its mind, perhaps that it reviewed the record and the submissions and made a different determination. But how did you show that you did not cause or create the issue?
So,
you
Your
put
Honor,
down the masonite, right?
our client put down the masonite, but the site was closed. Skyline was off-site.
Site was closed in that there was no work being done at the site. However, your witness testified that he or she inspected, or that the site was inspected on almost a daily basis during that period of time.
No, Your Honor. The witness that testified on behalf of Skyline came on the day of the accident to go do an inspection of the roof.
No, but wasn't there also testimony that the property had been, that the area was inspected throughout the time that it was not, there was no work being done because of COVID?
Yes, Your Honor.
I thought that's what I just said.
Well, I'm sorry, Your Honor.
Okay.
I thought you
I
said-
thought it was me. Okay.
No,
I thought I just said that.
I thought you meant by someone from Skyline. You're right. Someone did inspect the site every single day
Yes.
or multiple times a day, but it was plaintiff. Plaintiff was the one who inspected it, not Skyline. No one from Skyline was there from March 22nd until May. It was closed because of COVID. On the day of the accident, there was someone from Skyline there to do a roof inspection. They were brought up to the roof by plaintiff, who was a member.
Under the contract, wasn't your client responsible for taking reasonable precautions at all times?
They did when they were on site. They were.
So that requirement in the contract is suspended?
They weren't on site. They had no notice that anything was wrong. When they
No,
left,
so what my colleague is asking is that section of the contract what talked about your being responsible, you're stating that that responsibility ended with COVID or ended because they were no longer on site.
the contract was complied with. Within the record on page 321, Exhibit D, are Skyline's work logs, inspections, everything when they were there. While they were on site, prior to construction, during construction, everything was fine. In the records, no issues existed. When the site was closed, per Governor Cuomo's mandate that every site's closed, the site was in good and working order. It was safe. Everything was locked up. Skyline was off-site. They weren't allowed to be there. They weren't allowed to, by law, be there. And the only people that were allowed to be there was plaintiff and any people who lived in the building. As part of plaintiff's testimony, he said he went across the area where he got hurt multiple times, as Your Honor pointed out, and looked and inspected and did whatever else he had to do. That was not Skyline's responsibility.
So this goes back to my initial question, is how did you establish that you did not cause or create the condition in terms of the laying down of the masonite?
Within the record, all the records show that the masonite and everything else at the site was in good and safe and working order. The first and only time that Skyline ever heard of anything was after plaintiff allegedly got hurt here and we received this complaint, this lawsuit. There's no negligence here. There was no duty because Skyline was non-site. The site was closed. The only person...
But how do we know what the site, how you left the site? Because there was some testimony, I believe, that the masonite was not taped down or wasn't properly taped down. So how do we know exactly how you left the site? I think you left the site in March. Yeah, you left the site...
March 22nd.
March 23 until May 27.
When Skyline left, they have logs per code, per their regulations, and per their daily routine. All those logs show no issues. The only person who could have ever seen any of these issues is plaintiff on his weekly or daily inspections, as Your Honor pointed out. Skyline couldn't do that. They had no notice. Per contract, if there's an issue, plaintiff or a worker from the building is to write Skyline, say there's an issue, photograph it, which there's nothing in the record showing any issues during the 3-week period, 4-week period, whatever it might be.
The name of the witness that the defendant produced at EBT was Francisco Velez?
Correct.
And didn't he testify that he did inspection of the area approximately every day in April 2020?
He was there on that one day. He was
Not that day. During that period, he was going there every day to make sure that defendant's equipment was safe, according to his EBT testimony.
Your Honor, on the day of the accident, our guy went up there, Mr. Velez, and he was going to the roof, and he was led up by plaintiff here. There's no issues on any other date.
But what's the answer to that question regarding the defense witness testimony of going up every day?
If he said that in the record, then that's what he says.
Defendant Velez testified he was inspecting the roof and using the stairs where the accident occurred approximately every day at the time the accident occurred.
I don't remember that
So
testimony.
that in essence provides at least notice.
I'm sorry, Your Honor.
That in essence provides at least notice of any condition that existed in the premises.
I don't remember Mr. Velez going every single day, and there's no record, I believe, of him going every single day. Maybe it was a mistake.
He also testified that it was defendant's practice to replace the tape securing the masonite periodically to make sure it was secured.
And that is correct, and that's what case law says. But Skyline was not there. If there was an issue, then plaintiff would have told Skyline. They would have immediately come and fixed it
Wait,
because
Velez is Skyline, isn't he?
Velez is Skyline, but plaintiff was the one who inspected every day, not Velez.
No, but this is Velez saying that he did inspect every day. You have time on rebuttal.
Good afternoon, Your Honors. May it please the Court, Anthony DiStefano for plaintiff respondent.
Counsel, so your understanding that Velez stated that he inspected every day?
That was not my understanding, Your Honor. I'm in agreement with defendant's attorney here that I do not recall that, or I would have highlighted that in my brief, that it was
Okay,
Mr. Velez
very well
who
then.
did it.
So in terms, I'm sorry, go ahead.
No, go ahead, Kelly.
No, I was just going to say, was the duty to ensure that the area was safe, did that lapse at all because of COVID? Was defendant relieved of any duty to keep it safe because he was not there, or they were not there?
Right, Your Honor, I don't believe that it did. I don't believe that COVID suspended their responsibility for, as Your Honor's pointed out under the contract, to ensure that persons and property were protected. And specifically, there is nothing to indicate that that masonite was in fact taped down in the last log entry before they left the site.
Were they prohibited from accessing the job site during COVID?
Your Honor, there's no testimony in the record about what the prohibitions were and what Governor Cuomo's mandates were. I can only speak to what I know from other job sites, but obviously that's not specific to this case. But regardless, I think that one of the salient points here is the fact that Mr. Velez from Defendant Skyline actually went ahead of my client as he was going up the stairs. So first we have the argument that it was never taped down because my client says if it was inspected daily, the tape was never there. And Mr. Velez saying it should have been taped down. And in fact, he is aware that masonite can warp and need to be re-taped down. So if Mr. Velez is now there and he's a couple of steps ahead of my client, well, then that gives him the opportunity to at least turn around and say to my client, stop, the masonite is warped. Don't come up here. You know, there's a potential for you to trip and fall, or at the very least.
I'm not really sure about that argument. You're saying that just because he represents Skyline, or because he's a human being and saying, you know, watch your step?
It's his duty. It's part of his obligation.
It's part of his duty to say, watch your step?
It's part of his obligation to inspect what Skyline's work and its equipment and materials and how they were stored. And given, again, Mr. Velez's awareness that masonite can be problematic, that certainly gives him the ability, if not certainly the
But
authority.
they're going up at the same time. I wanted to turn back to something that your friend stated. Do you agree that the contract only provided that they had to be on site in terms of inspections that they had to conduct inspections while on site? And since they were not on site from March until May, therefore there was no obligation?
No, I disagree with that. The contract was continuing. The contract itself was not suspended. There's nothing in the language of anywhere that I've
Does the
seen that
contract
says-
talk about only on site?
No, it does not only talk about on-site. It talks about maintaining protection for the site, not while they were there. If they left for the evening and somebody walked up the stairs and fell, just because they're not on site, are they not responsible for the condition they created? Of course they are. They put the masonite down. My client testified very clearly the masonite was not there before the construction began. It only appeared once the construction did begin. And the fact is that they put that down, and they have no witness. Mr. Velez was not a witness with knowledge of how the masonite was applied to the stairs. He was not on the project. He was actually just sent there to inspect their equipment on the roof to make sure that it was safe and secure. So without a witness with knowledge saying that they put it down properly, that they taped it down, that they have documentary proof that they put tape on that piece of masonite and it was the last thing they did before they left for COVID, then there's no one to satisfy their burden. And they rely on a picture, and my client very clearly testified that the tape in the picture was not there on the day of the accident.
Well, these photographs were taken sometime after the incident.
And by defendant.
Yes.
So certainly they could have put the tape down and then took the photo, and my client said very clearly it's not there. Judges, we're just asking for questions of fact here. We're just saying that this is a condition that my client tripped on. I did make an argument under the industrial code. We withdrew that argument because we realized, the circumstances would be very difficult. But at the end of the day, it's only negligence. It's only, did they create the condition? Did they maintain this safely? Did they act reasonably and adequate under the circumstances? All of those are jury questions. And therefore, we ask the court to affirm.
Thank you.
Thank you.
There's nothing in the record showing that anything was wrong with the masonite. Counsel saying, going back and forth, did Skyline put it in, did Skyline not put it in? He doesn't know. There's no proof to show anything was wrong. The only thing that is clear in the record are Skyline's records showing that masonite was safe, the work site was safe, everything was clean and secure. When his client did inspections, as he testified to, nothing was wrong. There was no notice given to Skyline at any time. There was no duty because they weren't on site. It was closed. If it was open, fine, I understand. Then that would be a duty on Skyline, but it was not. It was different. It was COVID. It's a time in our history that's very different than any other time. So there's no duty because Skyline was there. There was no breach because nothing was wrong. If there was something wrong, plaintiff would have either taken a picture of it, reported it to Skyline, they would have fixed it, as you guys pointed out earlier about fixing the tape. They would have fixed it. And if there was something wrong when they left, then they would have fixed it at that time. But there's an intervening amount of time of 3 to 5 weeks between the accident and when Skyline left that something might have happened. And the only people who had access at that time were plaintiff, his coworkers, and anyone else who worked for the building. So between duty, breach, and the fact that plaintiff was walking up the stairs, there's a handrail there. He was going up. As you go up the stairs and you're looking ahead, what do you see? You see the platform where he ended up falling.
So that goes to comparative, right?
It does, but it's not the ultimate cause of what happened here. He was holding the railing. He was looking up, and counsel just said that Mr. Velez was...
I just want to say, these photos, I don't see a railing on. Oh, wait, I do. I see it's over on the side. I do see the railing.
And then there's also...
So your argument basically is because of COVID, any obligation to maintain the site, including inspection, was frozen.
Not at
And you had no obligation during that period of time.
Not at any time. It's if
During the period of time of COVID, from March until May.
Skyline still did periodic inspections, as we can see with Mr. Velez going there on the day of the accident. So when they go there, you do have a duty and obligation to look, and that's what he was doing when he was there. When he was not there...
But he was, counsel, he was going every day in April, right?
Right. I believe you're referring to page 72 of the record, correct, Your Honor?
Yes.
So on there, it might have been confused or whatever it was in terms of, was there inspection every day? Yeah, by the building, and then when our guy was there, by him. He says he was doing inspection every day. It doesn't mean that he was probably
It
there.
says you were doing inspections approximately every day back in April of 2020 on this job, sir. He says yes.
And that might have been something between an interpreter and him, because I believe both of us did not believe that as we went through this entire case. And just to finish up, counsel never dropped any industrial code. He lost on the lower court, and there was no labor law violation. And after he lost his labor law claims, 200, 240, 241.6, he now goes to his last resort, which is this, common law negligence.
Thank you both. People v. Wisdom.
Center for Appellate Litigation by Molly Booth on behalf of Mr. Wisdom. Mr. Wisdom was denied meaningful representation at his trial. His appointed attorney had not looked at the video evidence within 5 months of the start of trial, and as everyone in this case concedes, this was a video case. This was a video case.
I think he said, first he said he couldn't remember whether he didn't think he did, but then afterwards he stated at the hearing that he did in fact take a look at the video.
Yeah, so at trial, he turns to his client and he says, I haven't seen that before, and tells that to his client's family.
I haven't seen that before. It's not the entirety of the videos, right? It's just the video of the arrest.
It's the video of the apprehension that he forgot that he saw because he conducted his review of all of the videos in the case in one session at the DA's office over 5 months before trial. So in a case where the defense is mis-ID and you're...
Does he admit that?
Yes, absolutely. He says, in the hearing 301 to 303, he says that that is when he looked at the video in the case once over an hour and a half. And you might ask,
but he doesn't say that that was the only time he looked at the video, right? He just says that that is a time that he looked at the video.
That is the only time he looked at the video.
That's not what he testified to. How does that create ineffective assistance to counsel?
Well, effective assistance of counsel is reviewing the evidence. And the time he'd go to the DA's office to review the video, he let the DA show him the video that he planned to introduce. He didn't do an independent review. He was unaware that the complaining witness, who at the time he did the review was the complaining witness in attempted murder, had given a statement to the police. He didn't review it. And at the hearing, he says, if it wasn't what the DA showed me, I wouldn't have known about it.
But he reviewed the portion of the video that shows your client firing 3 or 4 shots, I don't recall how many shots, at the complainant across the street. So he reviewed that portion of the video that shows your client or committing the crime.
He reviewed...
I'm just asking, is that correct?
So
would that not be the most important part of the video that shows your client committing the crime?
That's a non-identification quality video that he reviewed that he then had to compare.
I'm sorry, what's a non...
It means that the video of the actual shooting...
I'm sorry, what is a
non-identification quality? I'm sorry, Your Honor. I'm a little punchy about this. But
Yeah,
like the video...
Why would that be? Why would that be? I'm not understanding how you could characterize it as that.
Because the video of the shooting, as I believe the people concede, the video of the shooting...
Just say it shows the back of the person.
Yes, it's the back of the person. That's right. And so what then defense counsel has to do is follow a trail of videos where eventually, at the people's theory, is you see a full face of the defendant.
In theory, that's a fact. You do
Right.
That's undisputed, right?
Yes, well...
I mean, we all saw the video.
Yes.
Okay, we all watched the video. So we saw an individual in certain clothing fire the shots. We saw them get out of that vehicle, that white, whatever that was, SUV, fire the shots, and then we follow the individual to the bodega where the individual takes off the hood, looks to be your client, and I think your client admitted that that was him, right? And we see a watch on his wrist. We see that same individual walking down the street afterwards and then tossing something into a trash can, right?
Yes,
And then we see the individual being arrested, I don't know how long afterwards, your client being arrested with that same blue watch on.
yes, and so let's say defense attorney sees that video 5 months before trial, and then trial starts, and he says, you should consider the offer. We have a shot here, but you should consider the offer. At the end of a CPW-2 trial, defense counsel asks for 4 to 8 years. He doesn't realize that it's a determinate term. That is both in his sentence
But he admits,
and on the record.
it's admitted that he made a mistake in terms of what the sentencing exposure was. But let's also keep in mind, your client was adamant that he did not want to take a plea.
He said, I would request a 5-year plea, Your Honor, and he was offered 7. At the eve of trial, he asked for 5. That is on the record. So this
Was 5 a legal plea?
5 is illegal.
No, he was asking for a plea bargain, but my point here is that the 5 is close to the 7 being offered, and that 5 that he would have taken is
But he couldn't get the 5.
the video.
But 5 is illegal. He couldn't get 5. 7 was the minimum.
Yes, so my point is that somebody who had an attorney who hadn't ever walked him through this video, who had never sat down with his client and said, this is what the people's case is. Look at these videos. Look how they're going to make out to be you. The person before that conversation would have taken 5, according to the record. But he doesn't realize until mid-trial, he's got an attorney saying, I never saw that.
I thought that the attorney testified at the hearing later on that he did go over this with his client, with your client, and tried to convince him or tell him that with the video, they had very little chance of success at trial.
Yes, but he also said the offer is pretty good, but not incredible. The case is triable. They could win. And then another
That wasn't
present for the conversation said that defense counsel had drunk the Kool-Aid before trial. He didn't order the hearing minutes before cross-examining the officer.
That was the Rodriguez. It was a Rodriguez hearing with the officer who knew the defendant. That's why it was a Rodriguez hearing. That had nothing really to do in terms of the video.
Any trial advocacy class is going to tell you, order the hearing minutes. You weren't there. Review the discovery. I don't think this court, or certainly anything in my experience, has seen someone start a trial and not be looking at the evidence, not have access to the evidence. The DA had access to the video, and he only reviewed them in the DA's office approximately 5 months before trial. And so it was that he forgot one video, because after 5 months, you might forget one of the key videos. That makes sense to me.
But he remembered the key video of your client committing a crime. But you do have time on rebuttal.
Good afternoon, Your Honors, and may it please the court, Samuel Goldfein on behalf of the people.
So it doesn't look good if counsel's saying he doesn't remember a key piece of evidence.
I agree with you entirely, except that it's key, but certainly it's not a good look that he didn't remember a piece of evidence. It was an important part of piece of evidence.
And he didn't order the minutes from the Rodriguez.
Well, he states that he didn't have the minutes on hand during the cross-examination, and there's some dispute about how he got the minutes, but the judge credited his testimony that he had obtained the minutes, and clearly the fact that he's asking a question about the hearing, about the substance of the hearing, shows that he is aware of what happened at the hearing. He necessarily hadn't reviewed the minutes.
But the need for the minutes is so that you can impeach the witness at any given moment if there's testimony that conflicts and is
Absolutely, Your Honor. There was no conflicting testimony. So there was no, he was aware of what happened at the hearing, and he was using that evidence to actually do the opposite, not to impeach, but to try and bolster favorable testimony that he had elicited from the witness. And then when the judge pointed out that that was not allowed, he withdrew the question. But to say that he was unaware of what happened at the hearing, he was necessarily aware of it if he was asking questions about what had occurred there.
Well, when we talk about ineffective assistance of counsel, what kind of conduct do we have to see from counsel for it to be deemed ineffective?
I think that, well, first of all, there has to be a showing of prejudice as the second prong, which I think is completely out the gate here. But here the judge did assume without finding that counsel not reviewing the videos sufficiently so that he had recalled the arrest video was deficient performance. The court did assume that that was the case. I'm not sure that that's true on this record because counsel, before the video is introduced, is making objections to it based on its substance. He says, I don't want the people to introduce this video. It's cumulative. It's just going to show him being arrested in the same vehicle and with a watch. They already have evidence of that. So he seems to be aware of the substance of the video. He certainly had seen the videos in the past, as the defendant accepts.
Well, that was the whole issue. He didn't review them. He had at one point in time seen the videos. He just did not review them in the 5 months prior to trial.
Perhaps he had a copy of the videos. He had given them to defendant. Defendant had lost the copy of the videos. He had provided a second copy of the videos to defendant. So certainly at some point in time, defense counsel did have these videos. He was also aware of their import. The videos show defendant firing his gun on a public street. You can track him to the deli. He's very distinctive, and the deli video leaves no doubt that it's the defendant. Under those circumstances, and especially then there's the GPS data, he's arrested in the same car. I mean, this attorney, the best thing he could have done was to convince defendant to plead guilty. And
I think he said that he tried to convince him to plead guilty, but the defendant maintained his innocence.
for months on end, and this was not the only attorney. 2 other attorneys also viewed these videos and also told defendant he should plead guilty. One of them enlarged still photos of it and sent it to defendant. Defendant had copies of the video for himself, so he could
Right, but
review
if you have one attorney telling you you can win this, right, that undercuts this advice to plead guilty, does it not?
Perhaps, Your Honor, but no attorney was telling, the attorney was saying if we're going to trial, there's reasons that I think it might be winnable. There's no gun recovered, the victim's not going to testify. There are reasons, but still, and the testimony from the other attorney, Klein, not Brown, the one who's being challenged, he says that still in that moment, they were still telling defendant he should take the guilty plea. So yes, the case was conceivably winnable, although very unlikely, but his best bet was to take the guilty plea. He refused to take that plea, and on that record, he cannot possibly establish any prejudice. 2 attorneys were encouraging him to take the plea when the plea was more significant than the one that was, there was a reduced plea that was offered that he still refused to take.
So in terms of plea bargaining, it's my understanding that you had originally offered the defendant 10 years.
That's correct, Your Honor.
And he, I'm not sure the order, but he insisted on 5, which was not in the cards apparently. The DA's office then offered 7, is that right?
I think it was 10, and then we dropped it to 7, and then he insisted on 5.
Okay, all right, and then, so ultimately it was 7 that
Correct.
you offered, right? And then after trial, after conviction, your recommendation to the court was 10 years, correct?
Correct, Your Honor.
Court wound up imposing 12.
Correct, Your Honor.
Why should we not exercise our power, our inherent power to reduce it?
I think 12 years was a fair and appropriate sentence given
That's
the
not what
violence.
you recommended, though.
10 years would also be fair and appropriate, Your Honor. I think it's in the range of reasonable sentence given defendant's violence. In this case, it's a gun battle in broad daylight. Fortunately, no one was seriously injured. He could have struck a bystander. He has a history that's replete with violence. He absconded from a parole violation on a previous attempted murder that he pled down to CPW. He's got a criminal history in Connecticut.
Presumably, the people knew all that when the people made its recommendation of 10 years, right?
That's correct, Your Honor. The last thing I'll say is there was no expression of remorse. If there's ever a case to express remorse, it's
Well, he's
one.
denying guilt.
He's caught on camera, dead to rights, committing this crime.
Well, he's still denying
He
guilt.
still maintained his innocence.
Absolutely.
And at some point, I think he wanted a hearing as to actual innocence.
My
I
point
think
is,
that was one of his pro se motions.
I think it was a point in the brief as well. I'm happy to talk about his actual innocence claim if Your Honors are interested. But for whatever it's worth, I think this is would be an opportunity if he was remorseful to have expressed remorse, and his failure to do so to complain that his prior
Well,
convictions
remorse
were
could
also
be something
erroneous.
that could be taken into account as an advantage. But when a person's not remorseful, that's consistently claiming it wasn't me, it can be used against them, can it?
And lacking remorse is different from maintaining that you're innocent.
Absolutely. Your Honor. I see my red light is on.
Thank you.
Thank you, Your Honors. I ask that you affirm.
I think this case is very similar to People v. Oliveras, the Court of Appeals case. We have in Oliveras a situation where a defense attorney had seemingly a hopeless defense. He sent out a subpoena, or he asked the judge to sign a subpoena to obtain records, and then he served the subpoena. And it turns out the records would have been completely useless, right? But he never bothered to get them. Here we have the hearing testimony supporting defense counsel only viewing videos that the prosecution intended to admit against his client. There was a question, so you let the ADA make the determination as to what was pertinent and what was not pertinent. Answer, of course. Now, I understand he goes mis-ID, which involves following the clothing of an individual at very granular level. And the people will say, like, look at the sneakers, they're gray, they have orange swipes on the side of them. And at closing argument, he tells the jury, listen, my client was wearing Timbs, those are very common, it might have been somebody else, essentially. And like, it's that kind of detail that—
I didn't follow that. What do you mean by that?
So we have to, the prosecution's case is made out by splicing through the video of the shooting where you don't see the face of the shooter, and then following who they say is the shooter until the bodega video. And they follow.
When you say who they say, right, they're following the clothing of what you're able to actually see in the video,
Yes,
right?
and if I, as defense counsel, had said, you know, that clothing's super common. It could be that there's somebody else who has the same clothing. Timberland boots, they're very common, jury. And it's like the video doesn't show Tim's. The video shows something that's much more distinctive, that's much more damning. And then he tells the jury that part of the prosecution's case is an intent to use a weapon unlawfully. And then the prosecution gets up and says, Mr. Brown, during his closing statement, had misapprehended the charges here. Like, there's at some point that the constitutional right to effective counsel protects the innocent and the guilty, and the Court of Appeals has made clear of that with meaningful representation. We're not simply saying these are mere losing tactics and we're sorry we came in second. It's the lack of preparation. It's the asking for an illegal sentence. It's failing to order the hearing minutes. It's all of that. It's eliciting unfavorable testimony after a motion in limine that was supposed to protect his client. All of those things failed him, and when he was appointed counsel, that counsel did not live up to the standards of New York's Constitution.
Would you have said that he should not have addressed that video description? Like, when you're faulting him for misstating the sneakers, what would have been the better course if you think that was an improper representation?
Yeah, so if I'm trying the case, I don't tell the jury my client is wearing common footwear, you know, Adidas sneakers or something like that, when the evidence just plumb does not show that. I think that's also something that's indicative of a lack of preparation here, is that he constantly refers to the videos as stills. I believe that's what he was working off of during trial. And so, like, I understand that these can be tough facts, but when you look at those tough facts,
there's a video of the defendant shooting.
Does that mean he doesn't get a lawyer, though?
No, it doesn't. What it means is that when you put all of this together, the issue becomes whether or not the overwhelming evidence of the defendant's guilt, whether it was overwhelming. And you take a look at that video, tracking the defendant to the bodega, etc. The jury saw this.
Respectfully, the standard isn't just overwhelming evidence.
No,
it's
it isn't.
meaningful
That's not-
representation under New York State. And that is what our primary
Yes,
argument
but
is.
overwhelming evidence goes to the issue as to prejudice. And so then how is the defendant, or how was the defendant prejudiced given the overwhelming evidence of his guilt?
The Court of Appeals says that the defense does not need to make out prejudice. There can be overwhelming evidence of guilt, but you still have to look at whether the prejudice is to the right to a fair trial, and that is where he's prejudiced.
Exactly.
Not the standard, not how much evidence there was in People v. Oliveris.
But the Court of Appeals has stated you still have to look at prejudice. But thank you very much. Last case for argument, Murray v. Planned Parenthood. Yes, Ms. Murray, whenever you're ready.
Amber, wait outside, please. She's fine. I come today to ask for, to reverse Judge Lau Frank's decision for dismissal of a motion back, so it could be brought back to the lower courts, because it was under medical malpractice. When it clearly was under Judge Kathy J. King, it was supposed to be changed back to ASA, Adult Survivors Act, and the clerk never changed it back, so Judge Lau E. Frank only saw the medical malpractice, and he ruled under medical malpractice. He said that it was time barred, but under ASA, there's no time bar, and he also said, I don't have section 2.255, which alleges incest, which I never alleged incest. So therefore, that's why he dismissed it. And I feel that that was an error.
I think he was saying that under the Crime Victims Act, you either have to show that there was some type of incest and/or there was some type of forcible touching or something, sexual abuse.
Yeah, he said that I didn't say 255 incest. No, I said under penal law 130, it was 130.5 and 130.52, which was the touching and without consent. And I also want to point out the fact that the respondent likes to say that they're not responsible, they're the parent company, when the parent company of Planned Parenthood, they're very involved in their affiliates. They pay for their affiliates' employees' maternity leave. If you look back in their financial documents, before 2023, when I brought it to their attention, they have it under paid family leave for affiliates. They lobby for their affiliates. They're very involved with their affiliates. That's why I took the parent company to court under ASA, because there is no time bar. And I also want to mention how right now it seems strange because the whole time I was asking the clerk to follow Judge Kathy King's decision to change it back to ASA because I filed it as ASA, but their defendants went ahead and changed the RJI to medical malpractice, which confused Judge Frank. But after I filed my brief, I looked back and they retroactively changed it to Adult Survivors Act. But the clerk, I don't believe it's the clerk, I believe it's the clerk specialist, but she couldn't change it to in the NICEF. So right now, if you look up that case, it still says medical torts dental. But in the e-file, she retroactively changed it to Adult Survivors Act. So the whole mishandling of my case with the clerk also caused Frank to make an error in filing that decision. But I could submit that it still says medical malpractice. Can I?
Well, we'll take a look at it to see what it says.
And also, I want to mention the fact that something else I wanted to mention. I guess. Do I have time to rebuttal too?
You have a time in rebuttal, yes.
Okay, to make it clear, because I'm a little bit nervous, I never wanted to be pro se. I asked like 10 lawyers if they would represent me, but they said they were not familiar with ASA. I don't think the judge knew about ASA fully, because I never said it was incest. I always said it was 130.52 and 130.5. I went into details in front of Judge King because the details are embarrassing. I'm sorry.
It's okay. So you have time on rebuttal. Why don't you have a seat and compose yourself, okay? Yes, whenever you're ready.
Good afternoon. May it please the court. Dean Pillarella for the respondent. The motion court correctly dismissed plaintiff's claims against Planned Parenthood, both as untimely and for failure to state a cause of action. On either ground, the court should affirm, starting with the statute of limitations. Irrespective of the administrative characterization of plaintiff's action, the complaint which plaintiff filed fails to allege or sufficiently plead any offense under Article 130 of the Penal Law, as is required to implicate the Adult Survivors Act in this case. Plaintiff effectively alleges that during the course of an abortion being performed, an unidentified doctor made, quote, illicit statements regarding her private parts. While this is certainly inappropriate, it simply does not rise to the level of an Article 130 penal law offense. Moreover, to the extent plaintiff alleged at least 4 times in the complaint that she was a minor at the time of the alleged abortion, her claims would in fact be governed by the CVA, not the ASA, and the CVA revival window had already been closed in 2023 when plaintiff filed the complaint. So based on those reasons alone, the court correctly dismissed the action as time barred. Irrespective of that, the court also correctly dismissed the complaint for failure to state a cause of action against Planned Parenthood. Number one, the complaint does not satisfy CPLR 3013's requirement to assert the material elements of any cause of action. In fact, there is no cause of action that's alleged, nor other material elements of any cause of action alleged. As we discussed in our brief, under this court's case of Guzman versus City of New York, that in and of itself is prejudicial to Planned Parenthood and warrants dismissal. Irrespective of that, there's no conceivable cause of action that could possibly be brought against Planned Parenthood in this case, because there's no allegation of any relationship between Planned Parenthood and the alleged doctor, or between Planned Parenthood and plaintiff, nor is there any allegation that Planned Parenthood had or should have had prior notice of any vicious propensities on the doctor's part. And lastly, as the Manning affirmation, which is contained in the record, discusses, in fact, Planned Parenthood is an improper party. So for all those reasons, the decision in order below should be affirmed, whether based on the statute of limitations or for failure to state a cause of action.
Thank you.
Thank you.
I just want to say, when I did the summons and complaint for public records, I didn't go into detail. I went into detail with Judge Kathy King, who heard all of the allegations and the 130.52 with the inappropriate touching, which is under ASA. I feel comfortable talking to her versus putting it on the summons and complaint for public records, and it was also very embarrassing. And it happened when I was 18, and I thought that you had to be 21, a legal and adult. So 18 is a legal age, and as an adult, not a minor. I also want to point out the fact that I went after the parent company, and they have this affiliation with their affiliates that they keep trying to deny. Even they also have a case, what I put in my brief, about Planned Parenthood versus Kennedy, how they do take over what affiliates do and how they're represented and how they're closely allocated. And I also put in there how they lobby for their affiliates, how they fund their maternity leave for employees. So I feel I had to go after the parent company because they're the umbrella and the affiliates are underneath it. And I just want to also point out the fact that under ASA, there's no time bar. I don't know why he keeps saying there's no time bar when they're under ASA, there is no time bar. So I'm just asking, what I filed my $305 just to go before ASA judge and have my case heard. They always kept me in motions for 2 years. Stopping this, I just asked that you allow me to go back before the lower courts and have everything heard, and I can have my piece and be able to hear my side. They're throwing it out right now saying that they want to dismiss it, saying that they're not responsible, but in the other court case, Christina Hyman, they never said anything like about being a parent company isn't liable. They let her go forward with that case.
Thank you. Thank you both.